Okay, we are back. So now we are in Chapter 6, Actions for Breach of Contract of Sale of Goods. So this is very short. Let's proceed. 1594 talks about actions or remedies in a breach of contract of sale of goods. So what are goods? Goods include personal property, includes growing fruits or crops. It does not include real property. Okay, so hindi kasama yung mga lupa dito. So what are actions, remedies available in case of breach of contract of sale of goods? So you have number 1, action by the seller for the payment of the price. This is found in Article 1595. Number 2, action by the seller for damages for non-acceptance of the goods. This is found in 1596. Action by the seller for rescission of the contract in 1597. Action by the buyer for specific performance in 1598. And action by the buyer for rescission for damage for breach of warranty. So let's continue. In 1595, we talk about seller's right of action for the price. Article 1595 provides 3 cases where an action for the price of goods under a contract of sale can be maintained by the seller. Ownership of the goods has passed to the buyer, and he wrongfully neglects or refuses to pay the price. Number 2, price is payable on a certain day, and the buyer wrongfully neglects or refuses to pay such price. Number 3, goods cannot readily be resold for a reasonable price, and the buyer wrongfully refuses to accept the goods. So these are the 3 cases where an action for price of goods under a contract of sale can be maintained or initiated by the seller. So example, the seller sold to B a specific refrigerator for 8,000. So the seller can maintain an action for the price in the following cases. First one, the seller has delivered the refrigerator to B, however, B refuses to pay. So dito, na-deliver na yung ref, pero ayaw pa rin magbayad ng buyer. Okay? Number 2, the seller has not yet delivered the refrigerator, but the period fixed for the payment has already arrived. So dito, may certain day na kailan babayaran yung ref, 'di ba? Although hindi pa naman na-deliver ng seller yung refrigerator, pero yung obligation ng buyer na magbayad on a certain day, hindi niya na-comply. Number 3, B has refused to accept delivery without just cause, and S has notified the buyer that he is holding the goods as bailey for B. So again, yung bailey is parang hinahawakan mo lang yung item. Parang kang bantay. Okay? Parang kang security guard over the item. Alright? So in these cases, S can maintain an action for a price. So pagbabalikan mo dito, action by the seller for payment of the price. So parang specific performance yan on the part of the seller. Inihingi niya na gawin ng buyer yung kanyang obligation, which is magbayad. Huwag titinan mo nga itong 1595 to 1599. Pwede mo yan ma-divide into 2 eh. Yung una is specific performance, either by the seller or the buyer. And then number 2, rescission, either by the seller or the buyer. And then damages, either by the seller or the buyer. Seller's right of action for damages. This is in 1596 na. If the buyer without lawful cause refuses to accept and pay for the goods he agreed to buy. Oo nga naman, ang labo. Diba? Bumili ka ng item, tapos nung nandyan na, ayaw mong tanggapin at ayaw mo pang magbayad. Number 2, ownership of the goods is not passed and the seller cannot maintain an action for the price. The seller's remedy is merely for damages. Number 3, goods are not yet identified at the time of the contract. The seller's right is merely for damages. 1597, seller's right of rescission before delivery. So, pwedeng i-cancel na nung seller yung kontrata kahit hindi pa na-deliver yung item. Here, the seller may rescind a contract of sale of goods which have not yet been delivered to the buyer. So, number 1, the buyer ito yung mga instances na pwedeng i-cancel ng seller yung kontrata. Number 1, the buyer has repudiated the contract of sale. To repudiate means to refuse to fulfill an obligation. In this case, to refuse to pay. So dito, yung buyer, ayaw niya talaga magbayad. So, since ayaw niya magbayad, sabi ng seller, oh, sige, cancel na lang natin. Ayaw mo naman magbayad eh. Number 2, the buyer has already manifested his inability to perform his obligation, which is, yung obligation ng buyer is to pay in the contract of sale. So, sabi ng seller, oh, since nagsabi ka na sa akin na hindi ka magbabayad, cancel ko na lang. Number 3, buyer has committed breach of contract. Aside from the obligation to pay and accept delivery, the contract may stipulate other provisions which a buyer must perform. Failure to do so is tantamount to breach of contract. So, tama ito. Kasi sometimes, hindi lang naman yung obligation to deliver the goods and the obligation to pay the price yung nakalagay sa contract of sale. Sometimes, may ibang mga provisions yan. Okay? Again, pag titingnan mo ang kontrata, anything you can put in the contract as long as it is not contrary to law, morals, public policy, public order. Okay? So, dito na tayo, 1598 na. Punta naman tayo dun sa right ng buyer. The buyer's right to specific performance applies if the goods to be delivered are specific. Tama nga naman. Kasi, kung general yung goods, kung specific, kung generic pala, hindi general. Kung generic yung goods, it can be replaced by anything, diba? So, ito, mag-a-apply lang yung specific performance kung yung goods is identifiable, specific, one of its kind. Here, the buyer will ask the court to compel the seller to deliver the said goods to him. Okay, 1599, remedies of buyer for breach of warranty by the seller. So, dito, yung seller yung nag-breach, okay? 1599 applies to both implied and express warranties. When the seller has breached his obligation or his warranty, the buyer has the following remedies. Okay, so, ina-assume natin dito yung situation na nag-deliver nga yung seller ng goods, tapos yung goods may depekto. Okay? Kasi na-breach yung warranty eh. I accept the buyer has the following remedies. Number 1, tanggapin niya pa rin yung goods and set up the seller's breach to reduce or extinguish the price. So, ito yung recoupment. So, natanggap niya yung goods, or sabihin natin sasakyan, tapos, sabihin na lang natin sasakyan yung example dito, ha? Tapos, yung sasakyan na natanggap niya, sira-sira. Pwede niya pa rin naman tanggapin yung sasakyan. Pero, sasabihin niya, pre, i-reduce na lang natin yung presyo nito kasi sira yung aircon, diba? O sira yung windshield, yung bintana. Yung automatic lock, sira, diba? Number 2, accept the goods and maintain an action for damages for breach of warranty. Okay. To reduce the price. Okay, ano bang pinagkaiba? Ito, damages naman ito. Accept the goods. In number 1, accept the goods and set up the seller's breach to reduce the price. Okay. Number 2, accept the goods and maintain an action for damages for breach of warranty. Okay. So, dito naman, ang sasabihin niya, didemanda pa rin kita, pre, kasi hindi mo ako pinatulog eh. Sabi mo maayos, tapos hindi pala. Na-stress ako dahil dito kasi mali-mali yung yung sinabi mo sa akin noong una. Ayan. So, number 3, refuse to accept the goods and maintain an action for damages for breach of warranty. Okay. Dito naman sa number 3, hindi niya na talaga tinanggap yung sasakyan na sira. Okay, refuse to accept. Pero magdedemanda siya for damages. Number 4, rescind the contract by returning the goods and recovering the price. Rescission. Sabi niya, sige na pre, wag na natin ituloy ito. Akin na yung pera ko. Balik ko na rin sa yung sasakyan mo. Yan. Okay, so number 1, recoupment, which is either to extinguish the price or reduce the price. So palagay ko hindi naman papayag yung seller na i-extinguish yung prices. So malamang baka ma-reduce lang yung price. Number 2 is action for damages. Number 3, ganun din damages, pero hindi mo tatanggapin yung item. Yung number 2 kasi tinanggap mo yung item tapos nagdemanda ka for damages. Yung number 4, hindi mo tinanggap yung item tapos hiningi mo na lang yung purchase price mo. Yung binayad mo. Okay, the remedies in 1599 are alternative remedies. So, pag sinabing alternative, that means once a remedy has been granted to the buyer, no other remedy can be exercised. So, pag hiningi mo specific performance lang. Pag hiningi mo is rescission, edi rescission lang. Okay? Pero I think yung damages pwede mong isama sa either rescission or specific performance. Exception, when the buyer chooses fulfillment of specific performance but the same is already imposed, In this case, the buyer may in the alternative sue for rescission. So, ang hinahabol mo talaga nung una, specific performance, sabihin natin na wala na yung item na specific or one of a kind. Sira na, di ba? Nawala na. Pwede kang mag-shift or mag-change to rescission na lang. Okay, so example, S sold 10 boxes of apples to B for 10,000 pesos. Parang ang labas, 1 box is 1,000. Upon examination, it was discovered that the apples equivalent to 6 boxes were rotten. So, in this case, the buyer did not pay. So, S filed a case against B for the purchase price. B can set up as a defense the breach of S of his warranty. Therefore, after, B can ask for a recoupment or a diminution of the price from 10K to only 4K, which is tama naman kasi yung 6 boxes at 1,000 pesos per box, that's 6,000 pesos. So, kung ang total na hinihingi niya ay 10,000, ma-reduce yun to only 4,000. In other words, from the purchase price of 10,000 or 10K, shall be deducted the 6K, which is the value of the rotten apples. B is only liable to pay the value of the apples received. Tama naman, that is fair. When rescission by the buyer is not allowed, if the buyer accepted the goods knowing of the breach of warranty without protesting, so alam niya na may sira, pero tinanggap niya pa din. If the buyer fails to notify the seller within a reasonable time of his election to rescind, so natanggap niya, nalaman niya na may sira, tapos meron siyang time, may reasonable time siya upang mag-complain, pero hindi niya ginawa, hindi niya nirescind yung kontrata. If the buyer fails to return or offered to return the goods in substantially good condition as they were in the time of the transfer of ownership to him. So, nung dumating sa kanya, ginamit niya pa, lalo pag nasira, pag ganyan, hindi na siya pwedeng mag-rescind. Rights and obligations of buyer in case of rescission. The buyer shall cease to be liable for the price. His obligation is to return the goods. If the buyer has paid the price or any part thereof, he may recover it from the seller. Tama naman yan. Nagbayad ka, tapos hindi mo nakuha yung pinag-usapan ninyo, di ba? Tama lang na mabalik sa'yo yung binayad mo. Buyer has also the right to hold the goods as bailey for the seller should the latter refuse to return the goods to him. Tama naman to kasi sa totoo lang, kung ayaw tanggapin ng seller yung goods, anong gagawin ng buyer? Iuuwi niya ulit, tapos babantayan na lang niya, as bailey na lang siya. In this case also, the buyer has a right of lien on the goods, proportionate to the price that he has paid to the seller. So, ang right of lien, yan yung karapatan mo dun sa isang bagay na pag-aari nung taong nagkakautang sa'yo. Okay? So, in this case, pwede niyang hawakan yung goods. Di ba, halimbawa, sabihin natin, balik tayo dun sa apples, yung sa apples, ang i-deliver sa kanya is 10,000 apples, di ba, or 10 boxes. Tapos dun sa 10 boxes na yun, 6 dun yung sira. So, ang ginawa ngayon ni buyer, pumalik siya dun sa seller, tapos binabalik niya yung 6 na boxes, ayaw ni seller. So, yung 6 na boxes, iuuwi niya. Babantayan niya lang. Ngayon, meron siyang right of lien yung buyer. Meaning, pwede niyang panghawakan yon hanggang mabayaran yung pagkakautang sa kanya. Kaya lang, yung apples na yan, posibleng mabulok yan di ba? So, ang tanong is, may right pa siya ibenta? Parang meron nata siyang right pag binasa natin yung previous na articles. Pero assuming for the sake of argument na hindi yun nabubulok na item, yung ano na yon, yung mga sabihin nating silver apples or golden apples, may right of lien siya doon na pangahawakan niya lang hanggang maisoli sa kanya yung pera. Okay? Na binangbayad niya. Okay. So, these are the questions for this particular topic. And, okay. With that, we end. This is chapter... I think this is chapter 6. Alright.